All right, let's turn to our big focus story at this hour. First, an oversight and then an overzealousness to evict the urban poor. That's the kind of approach that the top court has taken as it fumed over the eviction order to Haldwani residents, standing firmly by the cause of the urban poor. The court says thousands cannot be uprooted overnight, also cautions against selective application of law against the poor and the vulnerable. The Supreme Court orders a stay on the eviction order in the railway land in the Haldwani case and says don't treat urban poor as the discarded lot. Look at the timeline of events that's playing out on your screens right now. This is a case that goes back to 2013, the first PIL that was filed against illegal mining after a bridge collapsed over the Gola River. The court decided to widen the scope of the PIL and ordered all encroachments to be removed. 2016 is when the Uttarakhand High Court ordered a complete evacuation of 29 acres of railway land. 2017, the same High Court ordered the residents to vacate the encroached land again by February next year, but no notices were served. The case came up in the Supreme Court in the year 2017. The top court put a stay on the High Court order, asking it to hear the pleas of the residents first. Then later, of course, last year in March 2022, a new plea was filed asking illegal occupants to be evicted under Section 147 of the Railways Act, which deals with trespassing. 10 intervention pleas were filed. December 2022 is when the Uttarakhand High Court rejected all intervention orders and ordered an eviction from the encroached land. Today, the Supreme Court stayed that High Court order and has scheduled the hearing for the 7th of February. So on the 20th of December, the order that came from the Uttarakhand High Court directed railways and the district administration to use paramilitary forces to evict nearly 4,000 families. Think about it, these are poor families who would be stripped of the roof over their heads in the biting cold of the winters in December if that court order had to be followed. Now, these are people, of course, residing in these areas for years. They claim they have valid documents recognized by government authorities. The railways, on the other hand, is claiming that their land has been encroached by these dwellers. Taking exception to the High Court direction to remove the occupants in 7 days, the Supreme Court observed, and I quote, there cannot be uprooting of 50,000 persons in a week's time. Let's listen in to the inputs coming in.
देखिए, उस पर हमारा पहले से ही ये मानना था कि चूँकि न्यायालय का मामला है, न्यायालय जो भी आदेश करता उसके साथ हमारी सरकार उस पर आगे कार्रवाई करती, आगे काम करती। हम न्यायालय के रुख पर ही थे, न्यायालय जो भी आदेश करेगा वो हमेशा हमें मान्य होगा।
It's a huge sign of relief, and we thank the Honorable Supreme Court, because when we came here and when we discussed the entire case with our lawyers, we want to thank Mr. Salman Khurshid, Mr. Luthra, who represented us. We took all the anomalies of the decision made by the High Court and lawfully the anomalies based on law, and we got them here. Now, the Supreme Court considered those anomalies. They considered the people who've been living there for 50 to 100 years. They considered what the railway wants. And they have asked everyone to produce their papers, which we insisted from day one should be the case. That people, if railway is saying that it's their land, show us your gazette, show us your map, show us your papers. Now they've asked the railway to produce their papers. Now
so the state of Uttarakhand is also claiming that land.
State of Uttarakhand. 2/3 of that is Nazul land, which is Uttarakhand state government land, not railway land. Not for a single day did the government of Uttarakhand represent its people or protect its own land.
Court has appreciated the fact the first utterances from the Supreme Court was that it is a human issue, it's a human right issue. You cannot tell people who have been living there for 50, 60, 70 years to just go off within 7 days. Otherwise, paramilitary forces will be used. So there were 3 very important points which have been made by the Supreme Court. One, it's a human issue. You cannot tell people to go off from their land, from the place where they have been living, and they have a legal right, and they say that they have the documents for that. You cannot tell them to go away. It's a human issue. Second, the government has not prepared a rehabilitation scheme which was very much necessary in matters of development where you are displacing people. Thirdly, Supreme Court has taken a strong view on the issue that the impugned judgment of the Nainital High Court has made an observation that if after giving a notice of 7 days for evacuation of that land, these people did not vacate that land, then paramilitary forces should be used for vacation of that land.
Let me go across to our panelists joining us here this evening. Advocate Namit Saxena, Senior Advocate Sanjay Hegde, and former Commissioner of Information Commission Sailesh Gandhi. Very good evening, gentlemen. Thanks for joining us here on the program. Mr. Hegde, first to you, I want to just put across to you the arguments that we just heard, the points that we just heard, that the Supreme Court has taken a humane approach. It questions the fact that you cannot have people displaced in this manner without a rehabilitation plan in place. So in a way also questioning the state authorities for having failed to deal with this problem in a manner that could be considered justified, Mr. Hegde.
Yes, all that the Supreme Court has said would be logical even in a case where they are entirely illegal encroachers. But that's not the case here. Long ago in Olga Tellis and other cases, the Supreme Court, and even in the Narmada case, for instance, the Supreme Court said that while people may not have a right to squat on public land, but you cannot run bulldozers over them. You have to rehabilitate. That has been settled long before this bench. But here the facts of the case are even more startling. It doesn't start with 2013. It starts with an office memorandum of 1907. That's over a century and 15 years ago. So at that point of time, a lot of land was leased out by the then government. That is what is called Nazul land. Now, on those leases, which were which have been continued over a long time, people have built their houses, people have transacted property, and everything has happened.
Yes.
Now, the railway says that that deal in 1907 could not have happened, that office memorandum could not have happened because at that particular point of time, the railway's permission was required. This is the actual background of this case. Now, events which have happened over a century ago, if you want to tie it up all and shoot your way out of trouble in 7 days, then obviously the Supreme Court is going to intervene, right?
This is important. What you're saying is that, you know, the approach to this problem to deal with the urban poor in this manner because they do not have the wherewithal to fight for themselves, to assume that you can just simply displace them, give them a notice of 7 days, that wouldn't do. The difference is, Mr. Saxena, in demarcation of land between railways and the state is another contentious issue that has come up. In fact, in exposing one illegality or, arguing one illegality, more illegality is also apparently has been exposed in a way that this has become some sort of a legal tangle, this entire issue.
See, it has to be distinguished, who owns this land actually. Nazul land is what? Nazul land is non-agricultural land, which, the state owns for building buildings and roads, etc. So the state claims that this is Nazul land, because 2/3 of this actually, is supposed to be Nazul land. They have to give those documents. If the railway claims it, the railway has to give those documents. Those documents are to be on record. Objections have to be taken on those documents. We can't have that, they give 7 days to displace all citizens, from a particular area. And in case they don't vacate these lands, you use force against them. State can't just use force against citizens like this. So the Supreme Court is right in the approach of, asking for what is the rehabilitation plan with you? Where are all the documents? Have you heard all the citizens who are residing there? So all these factors are to be weighed in. It can't be, rushed up. Justice hurried is justice buried. So in case this has to be taken to a logical conclusion, that has to be through proper pleadings. Everybody has to be heard. Documents are to be on record. And then it has to be decided who actually owns what portion of what land. And what is the rehabilitation scheme, that in case you have to displace citizens who have been residing there for for decades altogether, how do you rehabilitate them. What is the plan? So it can't just be done in 7 days, in a week's time. This is not 2 minutes, Maggie noodles that, or pizza delivery in 30 minutes. In case Domino's does not deliver pizza in 30 minutes, you cashback offer. It can't be like this. These are serious human issues, as the Supreme Court has rightly pointed.
Yes. Mr. Sailesh Gandhi, where do you stand on this matter? Because, the way this case has progressed, and if you look at the previous orders, the High Court in its December 2022 order had also observed that the previous governments didn't do anything because of vote bank politics, alluding to the religious backgrounds of the residents as well. So there are multiple layers to this issue, and for a court to also point out that here is a case where politics has played up, and therefore this eviction that should have happened long ago was not allowed to happen.
I think on encroachments and land ownership or land usage, there is a complete mess up created by the legal system. In Bombay and in Maharashtra and perhaps all across the country, there are very rich people who are on leased lands, where the leases have expired. And
Yes.
they continue paying the old lease rents of 100 years. And these are very rich people, mind you. For the High Court to have said that within 7 days, the people should be vacated is, I think, completely inhuman. It's very sad that the Supreme Court has to intervene on something like this. But I feel there is a great need to define what is encroachment. These are simple principles that can be adopted. And as far as the right to shelter is concerned, I would submit that if you do not have a right to, you have a right to a shelter, but not a right to ownership of a shelter. What needs to be done in urban centers is rented accommodation provided by the government for people who have no house to stay. And this is possible. Details have been worked out and it is a possible thing.
Yes.
Unfortunately, Supreme Court has to keep intervening on matters which are not concerned with legalities, but something like 7 days eviction, I think is completely inhuman and unthought of.
Yes. Mr. Hegre, what Mr. Sailesh Gandhi is pointing out is also something that the court perhaps is cognizant of, because it talks about the selective approach being taken in the application of law. In those parts of our cities where, for example, land zoned for agricultural purposes have been converted to luxurious farmhouses of the rich and the wealthy, bulldozers don't seem to go there.
They don't. There was Chief Justice Kirpal who described the independent republic of scenic farms. That is one of the richest areas in Delhi, but it can't be regularized. The people live there with huge generator sets, and they have their farmhouses there. You will never find a bulldozer going there. Yes, the law in its majestic equality forbids both rich and poor to steal bread. That's what Anatole France wrote nearly a century ago.
Yes.
But at the end of the day, the law is the law. However, what was happening in this case, to a certain extent, was also the state government, which was the successor entitled to those who had originally leased the lands. The state then, at an earlier stage, did not particularly defend its people. It said, no, this land does not belong to the railways. At best, the railways can acquire the land, pay compensation, and move people out. That is the logical solution under the law. But what was being sought was that, no, there is a particular claim under an interpretation by which the railways would have the land, saying that it was railway land all along, and that they wanted to expand. So it's been falsely posited as a certain amount of people blocking development. And it's very easy to think on those lines. You either rehabilitate the people on this land if you want to expand your lands, or you acquire the land by paying reasonable compensation. That's the way to go about it.
Yes, the whole harshness of this method of simply slapping an eviction order on the poor and expecting them to vacate within a period of 7 days, that is something which I think all three panelists have rightly highlighted is something that cannot be expected for the top court to even endorse at all, and it has rightly pointed out the fact that you cannot, it says, overnight vacate 50,000 people. But here is a case, Mr. Saxena, of, the higher court taking a complete opposite view in a way of what the High Court said. The High Court, in fact, said the state governments did not act because of political considerations. They should have been evicted. The Supreme Court also questions the government, but on a completely different point, on why didn't you have a rehabilitation plan first before you even went to the extent of slapping eviction order. What I want to ask you is, what will this case hinge on now going forward? The matter is not settled yet.
See, the Supreme Court is seized of the matter. They've just issued notice and they've called for response from the state government as well as from the railways. They've also asked the railways that what is your rehabilitation scheme? How do you plan to rehabilitate them? So, we have to see how it goes. But, see, you have to see, you're right in saying that the High Court, the Supreme Court has, the observations made today, they seem to, to properly perhaps overturn what are the observations made by the High Court were. But, see, law does not recognize political considerations. Even assuming that, that there were political considerations for successive state governments, even then, the law does not recognize, whatever political considerations were there. Irrespective of the religion, irrespective of everything, if there is an encroachment, the law has to, deal with it with an equal arm. It can't be different for the rich and different for the poor, different for a particular community, another one, for another community. Right. This is what the High Court has, primarily gone ahead with. But we have to also understand something which perhaps the Supreme Court may eventually do so, that that the High Court of that particular state is perhaps more equipped to understand that there may be certain ground realities or there may be certain political considerations. Now, the constitutional courts, we can't assume them to to be immune from whatever societal or political environment or political climate in that particular state is. So that may have perhaps weighed in favor of this 7 days order by the High Court of Uttarakhand. But the Supreme Court has rightly said that even assuming everything is there, even assuming that political considerations are there, law does not recognize them. Yes. So it can't be that you go against the citizens. The state cannot be a bully against the citizens like this. So the Supreme Court is right in the approach.
Right. Quick last word to you, Mr. Gandhi, that that different standards are being applied for the same law, and what I think all three of you have agreed on, that there should be an equal application in the same way the poor and the rich must be treated when it comes to the issue of encroachment.
Article 14 of the Constitution has been suspended in our legal system. And that is the truth. That's the real truth, which we don't face up. And in our courts of law, Article 14 is violated every day. Every day, and I'm saying this with great pain and without exaggeration. And Mr. Hegde will bear this out. This needs to change. The law must be applied equally to the poor and the rich, which is not happening. And whether it's due to corruption, due to political considerations, I don't know. But we need to correct this, and the Supreme Court must take cognizance of this.
Namit Saxena, Sanjay Hegde, Sailesh Gandhi, thank you so much for joining us here on the program with your views on the subject.